Hello everyone, I am Anirudh and I welcome you to Company360's YouTube channel. And today's video we will discuss about remix music and its interplay with copyright laws. तो चलिए इस वीडियो को शुरू करते हैं. The essence of copyright law is to protect the collective efforts put in by creators who produce work that has some intrinsic value. Music, created through a collaboration between musicians, producers and composers, is one such work on which copyright subsists. यानी कि म्यूजिक जो बनकर आता है उनमें इन सब का एक हाथ होता है. When this music is altered, distorted and transposed by adding new compositions to it, a remix is formed. Thus, in a broad sense, a remix can be defined as a piece of music whose original state is altered by removing or adding parts of the original composition or by changing its components, which may include its tempo, bass and beats. A remix can also be considered as a musician's original work which is derived from the original track that is being used to create the remix. Several musicians, especially in the film industry, tend to create remix versions of hit songs from the 70s, 80s or the 90s by re-recording the songs and by altering its musical components. जैसा कि हम लैला मैं लैला, द हम्मा सॉन्ग, तम्मा तम्मा अगेन ऐसे गानों में देख सकते हैं. Since the original songs are works on which copyright subsists, copyright laws play a significant role in the realm of remix music. From an international perspective, it has been noted by the WIPO, that is the World Intellectual Property Organization, that most countries do not effectively address the laws that may be applicable with respect to remix music. Article 13 of TRIPS, that is Agreement on Trade-Related Aspects of Intellectual Property, mentions that certain special cases which do not conflict with a normal exploitation of work and do not unreasonably prejudice the legitimate interest of the right holder. इसका मतलब यह होता है कि जब तक रीमिक्स क्रिएटर कोई भी मॉनेटरी गेन्स प्राप्त नहीं करता है तब तक जो एक्सक्लूसिव राइट होंगे ऑथर के वो बहुत लिमिटेड रहेंगे. द रीमिक्स हियर विल बी कंसिडर्ड एज एमेच्योर क्रिएटिविटी. Another necessary condition that should be satisfied under Article 13 is that the remix music should not threaten the commercial viability of the original work. Article 10 of the Berne Convention also explicitly states that it is permissible to create work that is a derivation of the original work, but it should be compatible with fair practice. While several countries are unclear on their position with respect to remixed music and copyrights, some countries have laws that are specifically in place for non-commercial user-generated content that could be applicable to remixed music. Canada's Copyright Modernization Act is one such example. Article 29 of the Act explains certain conditions under which a work would not amount to infringement. The use is done solely for the non-commercial purpose. Second, the original source is mentioned. Third, the individual has reasonable ground to believe that he or she is not infringing copyright. Fourth, the remix does not have a substantial adverse effect on the exploitation of the existing work. In India, Section 2, subsection P of the Copyright Act 1957 defines a musical work as a work that comprises of music and includes graphical notifications of the work, यानी जिसमें म्यूजिक और ग्राफिकल नोट्स जो आप देखते हैं वो होने चाहिए. However, the definition of musical work under the Copyright Act specifies that the copyright does not subsist upon any words or actions that are intended to be sung, performed or spoken along with the music. Moreover, Section 13 of the Copyright Act specifies that copyright subsists on an original musical work, as well as a sound recording. In a digital age like today, the internet and several other platforms are largely unregulated. This could lead to a creator's work being misused under several circumstances. Although remixed music cannot be considered as a misuse of an original track, rather it is the derivative work of the original music composition. However, in order to ensure that a person does not wrongfully exploit another creator's musical composition through remixing, certain conditions have to be satisfied before remixing a track. Once these conditions are satisfied, the remix song will not be considered as an act of infringement. Such conditions are specified under Section 52, subsection 1, clause J of the Copyrights Act. सबसे पहले ये ज़रूरी है कि आप ओनर का कंसेंट ले ले रिमिक्स करने से पहले. In other words, a person cannot remix a song without consent from the original track's composer. In Gramophone Company versus Super Cassettes, an audio cassette titled Ganpati Aarti Ashtavinayak Geete was to be recorded. In order to make a sound recording, the defendants approached the plaintiffs with an offer to pay a license fee. However, the plaintiffs did not give their consent to the defendants for the usage of the sound recording. और आगे जाके डिफेंडेंट ने प्लेंटिफ से कंसेंट ना लेते हुए उस साउंड रिकॉर्डिंग को अपने ऑडियो कैसेट में डाल दिया। It was held that the plaintiff's consent was imperative for using the sound recording under Section 52, subsection 1, clause J of the Copyright Act. Secondly, it is crucial that the person creating the sound recording must mandatorily provide a notice of his or her intention to make the sound recordings to the owner of the original work. Additionally, the person making the sound recordings should also provide the copies of all the covers or labels which consist of the original track and has to pay owner a work royalty at a rate which would be fixed by the copyright board. इस रॉयल्टी का मतलब यही है कि जो रिमिक्स बना रहा है वो उस गाने के ओरिजिनल ऑथर को वो पैसे देता है ताकि वो उस गाने का रिमिक्स बना सके। Under this section, there are several conditions that the creator must be wary of before creating the derivative work of the original track. For one, no alteration must be made without the consent of the owner of the original track. Moreover, the alterations that are not reasonably necessary for the purpose of making the sound recording should be avoided. Secondly, the derivative work that is created must not be released in a packaging that is likely to mislead the general public. This means that the packaging should not delude the public as to the identity of the owner of the original track. Thirdly, a sound recording of the original work shall be made only after the expiration of 2 years after the end of the year on which the original track was recorded. In other words, a creator cannot create a derivative work or a sound recording of the original track within 2 years after the end of the year on which the original track was created. Lastly, a creator who creates a sound recording of the original work should mandatorily allow the owner of the original track or his authorized agent to inspect all records and books of accounts related to newly created work. While Section 52, subsection 1, clause J does lay down the guidelines with respect to sound recordings that are created as a derivative work of the original track, the section is largely ambiguous on several fronts. For example, आप देखेंगे कि इस एक्ट में कोई भी इंसाइट्स नहीं दी गई है कि एक व्यक्ति एक गाने का रिमिक्स वर्जन प्रोड्यूस और पब्लिश कैसे कर सकता है डिजिटल प्लेटफॉर्म्स जैसे कि साउंड क्लाउड और यूट्यूब पर। Moreover, the Act does not specify up to what extent the sound recording can be altered or what is the minimum amount of royalty that must be paid to the creator of the original track. Not setting a minimum amount that should be paid as royalty may be greatly disadvantageous to the budding indie musicians whose work would get exploited. However, the digital space and the music industry is developing at a breakneck speed. With such developments on the rise, it can be anticipated that Indian copyright laws would be amended with changing times. इस आखिरी पार्ट का अर्थ यही है कि म्यूज़िक इंडस्ट्री बहुत ज़्यादा बूम हो रही है और इसके लिए इंडियन कॉपीराइट्स एक्ट को बहुत ज़्यादा अमेंड होना पड़ेगा ताकि इस बूम के साथ वो एक्ट्स कोप अप कर सके, वरना जो हमारे इंडिया के नए बडिंग म्यूजिशियंस हैं उनके लिए ये लॉ काफ़ी नुकसानदायक हो सकता है। अगर आपको इस विषय पर और जानकारी चाहिए तो कंपनी 360 की वेबसाइट को ज़रूर भेज दें या हमें यहाँ दिए गए ईमेल और मोबाइल नंबर पर कॉन्टैक्ट करें। अगर आपको ये वीडियो पसंद आया है तो वीडियो को लाइक और चैनल को सब्सक्राइब जरूर करें। इस वीडियो को देखने के लिए मेरी और कंपनी 360 की ओर से धन्यवाद।